And so welcome back to continuation of discussion of shares. At our last session, we discussed sessions 42, 43, 44, and 45. We understood what shares are. Essentially, the unit of interest which a person has in an incorporated company. So that is shares. And then we also got to know that shares, their legal nature is actually movable property, like a shows in action. If you have a grievance regarding a share, you cannot just resort to several measures. You have to go to court by a legal action, and then you get your remedy. And again, we also noted that in Ghana, we operate what we call the concept of no par value shares. That is to say that the share regime or the system that we practice here is that the company upon incorporation need not impose a particular value or price on its shares in the incorporation document or in the constitution, and says that for us, we are registered with this total number of shares at this amount each. It doesn't really work like that, because we don't have par value. We have what they call the no par value. Now, we notice that in the par value regime, they will say that the shares are 100,000 at maybe 1 cedi each. But in practice, when the shares are being issued, they may be issued at either a price above the 1 cedi, maybe 1 cedi 50 pesos, or it may be issued at a price below, maybe 50 pesos. So if it's above, we say that they're issued at a premium. If it's below, we say that they're issued at a discount. Now, all these bring some kind of unnecessary confusion and artificiality. And that is why in Ghana, we have moved away from the par value concept, which is practiced in English company law, and have embraced the no par value shares, so that the price of the share is not so much about any nominal or face value, but what the going rate is dictated by demand and supply or whatever negotiation, as whether the company is also listed on the stock exchange or not listed, and so on and so forth. So these were some of the things that we noted. And I think the last thing we also made mention of was the fact that when it comes to payment of shares, when shares are issued and you need to pay for it, the general rule is that you must pay for shares by cash. But just like a lot of general rules or principles in law, we have exceptions. So we have exception to the rule that shares should be paid for by cash. And the two important exceptions are where you have capitalization or bonus issue. That is to say that existing shareholders are entitled to be given dividends. Instead of paying them the dividends, you decide to plow back that money into the company, and you give the shareholders equivalent number of shares, right? If I say equivalent number of shares, that is the number of shares which reflects the total value amount of dividend which will be paid to them. You give it to them. So that is what we call the capitalization issue or the bonus issue. And the typical reason for that is the company wants to raise more money. At the same time, it does not want to distort the balance of shareholding and so on, and does not want to bring in also new shareholders. Yeah, so these were some of the things that we said may justify capitalization of bonus issue. And again, the other exception to the rule that shares should be paid for by cash is where you are doing in-kind payment, or what you call it, a non-cash payment, in which case the shareholder is giving either services, right, providing certain services to the company, and the value of the services or the particular item which the person is giving to the company will have to be valued, and then the agreement under which the company accepted that would need to be registered with the registrar of companies. And that is very important, as we noted, that should it happen that the company is, for example, undergoing liquidation and a liquidator is appointed. The liquidator is appointed.
Media, please off your mic, please.
Yeah, I've muted here. Thank
Media.
you. And the liquidator is appointed. The liquidator could, for example, determine whether the in-kind payment or the non-cash payment was actually fair and the company was not cheated, and so on and so forth. So these were some of the things. So tonight we want to move on to discuss section 46, 47, 48, 49, and hopefully 50 and 51. So let me share the screen. And as I keep telling you, we are discussing the law itself. So where you are not clear on anything, please don't hesitate for us to know so that we can explain further. Good. So there's what we call the return of issues, right? Of course, in company law, as we noted from last semester, that there are a lot of documentation which is required of the company in relation to the registrar of companies. In other words, the number of documents which the company is required to be submitting to the registrar of companies, because don't forget that the registrar of companies is the regulator. He is, or he or she, I'm talking about the institution, not the particular person. The registrar of companies is supposed to be like the public watchdog, right? Trying to protect the interests of the public so that those who have been given the vehicle, the corporate vehicle, they will not abuse that vehicle. And one of the documents which the company is required to issue and also submit is what they call the return of issues. So like returns is quite common. Those of you who work in the court registry, the judges and the registry are supposed to do their returns concerning cases that they handle in a month and so on. Those who do work for water works and collect the various rates and so on, you do your returns. So it's not anything really new. So if you are supposed to do a document, which is a form of like a report, so the return of issue is actually which you are supposed to submit to the registrar of companies regarding the various steps which the company has taken regarding shares. How many shares have been issued? How much was paid for by cash, non-cash payment, and so on? What type of shares were issued and all that? All these matters are supposed to be spelled out in the document. And that document is called Return of Issues. And for that matter, Section 46 of the Companies Act states, and I quote, where a company issues shares other than a reissue of treasury shares as defined in subsection 3 of section 61, the company shall within 28 days after the issue deliver to the registrar for registration a return in the prescribed form showing us at the date of the return the following information. So A, the amount of stated capital attributable to each of the items specified in subsection 1 of section 68. So like the stated capital of the company, how much money the company is actually running with as raised. But there are various components which go into that. And the components which go into the stated capital have been spelled out in section 68. So if you go to section 68, for example, we will be told that stated capital is made up of, if you like, three main things. One, the total proceeds of every issue of shares for cash, including amounts paid on calls made on shares issued with an unpaid liability, less deduction for transaction costs that are direct in the sender to the share issue. Simply put, section 68 1A is saying that one item which is included in trying to determine the stated capital of the company is the proceeds from fresh issue of shares. If you say, fresh issue of shares, that is to say that when shares are being issued for the first time, as opposed to, later on we come and talk about redeemable preference shares and so on. Sometimes shares might have been issued to someone, then the company will get the share back. When the share comes back to the company, we call the treasury share, right? Now, when we talk about 61A in terms of the proceeds from the issue of shares, we are actually referring to, if you like, the fresh issue of shares, the money that you got, the cash payments. And then 68 1B, total value of consideration. So the non-cash payment, because the non-cash payment is also payment. So if you've issued shares, some have given you 10 acres of land as a payment. The 10 acres of land, for example, have to be valued. And when that is valued, that will come under what section 68 1B is talking about as forming part of the stated capital. So the value of the, if you like, the non-cash payment, that is another component of the stated capital. And then the third component is the total amount which the company by special resolution resolved to transfer to stated capital from reserves as defined in section 70, including credit balance on the shell deals account referred to in section 65. Okay, so if you talk about reserve, simply put, the company is trading, right? The company makes significant profits and all that. Now, when not until dividends are declared, all those things are money of the company. The company can decide to pass a resolution that we are transferring this money sitting in our reserves, for example, to go and add to the stated capital, so that the stated capital will be enhanced. So these three items constitute the stated capital. Or if you want to be very simple, regardless of the seemingly complex language which is deployed in section 68, trying to explain stated capital, all that stated capital comes to is that how much money have we actually raised in giving out shares of the company? And the money can be in various ways. Cash itself, which are paid immediately. Or if somebody was allowed to have, if you like, the shares paid on credit basis, So pay half of the shares, and another half will be paid later on when you ask you to come and pay. So we have unpaid liability. From time to time, we make a call on you to come and pay the unpaid liability. Now, all that money is still part of money from the issue of the shares, and it will hit the stated capital of the company. So that is what section 45 A is referring to. Then B, another matter which you should also report on, which you should state in the return of issues, the number of the authorized shares of each class. Now, we noted from our previous discussion, especially when we were discussing section 44, right? Issue of shares. We made the point that the number of shares, the authorized number of shares, which the company may issue is very much dependent upon how many shares the company registered at the time of incorporating the company, or if they have subsequently made alteration in accordance with the law. Again, section 44 also drew our attention to the possibility of the company having different types of what? Shares. Having different types of shares. And because the company can give different types of shares. So we go to 44, talk about different classes of shares. Now, if you are reporting on the shares to the registrar of companies in the form of the return of issue under section 45, you are required to tell the registrar for the various classes of shares which your company operates, how many of each class have you given out? Here, I'm referring to, let's say, preference shares, for example. You may have maybe preference shares, class A, class B, class C, and so on, with different bundle of rights attached to them. So when you are sending a return of issue, which I said is just a report you are sending to the registrar of company giving certain information, the information you have to give include the actual number of authorized shares of each class. So and then see total number of the issued shares of each class and the amount of money paid on the shares. So you've told us that you have different classes. You've told us the number. Now, for the authorized number of shares for the various classes, how many of them have actually been issued? Because remember, authorized shares is not equal to total number of issued shares all the time. You can have authorized shares being greater than total number of issued shares. But total number of issued shares can never be greater than authorized shares. There's a bank in Ashanti region, which, of course, not only that bank, there are a number of those rural banks, which found itself in that situation and was dragged by one of the shareholders to court, to the commercial court in Kumasi. And that shareholder litigant, his plaint or his concern was simply that the company has been issuing shares far in excess of the total number of authorized shares. That is the maximum number of shares, which according to its incorporating document, it is permitted to issue. The company has given out shares over and above that. And for that matter, that litigant wanted the court to make a declaration that all shares which have been issued over and above the authorized number of shares are null and void. And for that matter, the holders are not considered proper members of the company. The matter went to court, but I don't want to, of course, you can go to the commercial court and check. I don't, but for marketing purposes, I don't want to mention the name of the bank. Otherwise, it will attract a negative reputation, although it actually went to court, but I'm not mentioning the name. Now, the bank found itself in a very difficult situation. And at some point, I think they had to settle the matter, because the difficulty was this: if that case was actually to be successful, if the court were to agree with the claim being made by this litigant that shares which have actually been issued by the company far in excess of the authorized number of shares should be declared null and void, there's going to be chaos. Chaos in the sense that if, let's look at it this way. If you were one of the shareholders, right, whose shares have been declared as having been outside the range of total number of authorized shares, and you're asked to come and collect the money you paid at the time that the shares were issued to you and leave the company, will you take it kindly? Especially so when the money you paid probably 10 years or 20 years ago, something quite small, something fractional, compared to how the value of the company and its shares have actually grown. So these were some of the difficulties, but it's good we are students of company law. Some of these things, they appear very simple, but we need to be critical and open our eyes and take simple matters serious. It is not for joke that the law requires that when you are registering a company, you must tell us the total number of authorized shares. And again, should it become necessary for you to increase it or reduce it, the law provides a procedure. You must go through that. You don't just keep giving out shares to shareholders when you have exceeded the authorized number of shares. Good. The fourth item or the fourth information which need to be stated in the return of issues is what we have in 45D. The total number of the treasury shares of each class. If we talk about the treasury shares, we will come and discuss what we call like the preference shares and so on later. So treasury shares refer to shares which were issued by the company some point in time, but for some reasons, they have returned to the company. And the typical one being where you have redemption, right? Where you have redemption of redeemable preference shares, or maybe where you have a forfeiture. Forfeiture, that is to say that shares were issued and maybe the shareholder did not abide by the strict terms of the shares, including payment and all that. And the company exercised its rights under the agreement and forfeited the shares, meaning that took back, canceled, the shares. That will also be part of the treasury shares, which we are talking about. But the exact statutory definition of treasury shares is in section 61. Section 61, we will get there and discuss it. But just as I have indicated, basically, shares which have been issued before and they have come back to the company, either through redemption, or the company has purchased the shares back, or the company has acquired the shares back, or the shareholder is saying that, well, I'm no longer interested in this company, please take back your shares. They have been surrendered, and then the company has taken it back, and so on and so forth. So all these will let the shares which were previously issued come back to the company. And when they come back to the company, they are treated as treasury shares. They are different from unissued shares. Unissued shares are part of the authorized shares, which have never been given out. Treasury shares were part of the authorized shares. They were once given out, they were once issued, but have come back to the company, so know the differences. So if I say that treasury shares are unissued shares, if you say true, that would be wrong, because treasury shares have been issued before. Unissued shares have never been issued before, since the company was incorporated. Because if the company has the authorized number of shares, there's no compulsion on the part of the company to actually issue or give out all those shares. No, it will only give out shares as and when it wants to issue shares. So let's keep that in mind. Now, this return of shares is very important. Why is it so? The return of issues, as I said, enables the registrar of companies to actually get an updated information on the shareholding and then the share situation of the company. And again, don't forget that later on when we are discussing protection of minority, right, a majority rule, or the so-called rule in force and habital, and then the exception to that. We will discuss the remedy against oppression. We discuss the inspection role, which the Register of Companies play, so that if someone should go to the Register of Companies and complain that he or she thinks that the way and manner the affairs of the company are being run are in disregard of his proper interest as a member, or they are being done prejudice to his interest as a member, and for that matter, the Register of Companies should intervene. The Register of Companies will appoint inspectors to go and look into the affairs of the company. And following that, the necessary measures will be taken, and consequential orders may even be made if it will even go to court and all that. So the information which is supposed to be provided in the return of issues will certainly help the Register of Companies as a regulator to be able to do that. And not only the Register of Companies, if anybody is interested in acquiring interest in the company, you can go to the Register of Company and independently of the particular company, find out information about it before you make up your mind as to whether you want to go and buy the company or you don't want to go and buy it, and so on and so forth. So if you look at the Vodafone Ghana, for example, I think it's undergoing some form of merger or takeover or acquisition arrangement. And all these informations are important in helping the prospective buyers to make up their mind. Now, in view of the importance of the documents, which we call the return of issue, which has to be submitted to the Register of Companies, where the company decide to ignore that, decide not to comply with it, because the law says that within 28 days after you have issued shares, you are supposed to send the return. That is a report. So where you have ignored that, you default, then there will be sanctions, and the sanctions are what we see in the section 47. Those are what you see in section 47, and where the default occurs, the company itself and every officer of the company who is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the default continues. You see, unlike the previous approach, where the penalty units will have to be inflated and all that, and then at that time you have to probably go to court but now with administrative penalty units, the registrar can just inflate it. The registrar does not need to go to court. Once the registrar, if they are doing their work well, if they get information and that you have not complied with section 45 and 46 regarding the return of issue, right away they can send the administrative penalty unit for you to pay. Okay, so we would like to revisit an issue we have discussed before. What does it mean to pay for shares which have been issued to you in cash? Now, don't forget that company law is highly statutory, meaning that almost everything is actually spelled out in one statutory provision or another. And that is why the lawmaker will go out of its way on a lot of occasions to tell us what certain things exactly mean. So shares are actually paid for in cash according to the understanding provided in section 48 of the Companies Act 2019 Act 992. And what is that understanding? Let me quote section 48(1). Quote, for the purposes of this act, shares have not been paid for in cash, except to the extent that the company has actually received cash for the shares at the time of or subsequent to the agreement to issue the shares. Good. So we don't want to have any ambiguity at all as to whether shares have been paid for in cash or not. And the simple position is that you are said to have paid for the shares by cash when the shares are given to you. You immediately give cash, or you decided to pay maybe for the shares at a later date, and you are going to pay by cash. That will also suffice as payment in cash. Then 48(2), where shares are issued to a person who has sold or agreed to sell property, or rendered or agreed to render services to the company, as happened in the case of Aussie Air and Darko, if you remember, or to the persons nominated by that person, the amount of money of payments made for the property or services shall be deducted from the amount of cash payments made for the shares, and only the balance shall be treated as having been paid in cash for the shares, despite an exchange of check or any other securities for money. Yeah, so we are looking at the situation where you've done some service, right, or you've given some property to the company, and at the same time you also pay. Sometimes you can have what you call like the split payment. You pay for some of the shares by giving cash, and the other part you want to use some other things. So that is what section 48(2) is speaking to. That for purposes of payment in cash, it is the actual cash which will be reckoned as such, because the law also provides for non-cash payment. So the other portion of the payment, which you are going to use the agreed service or the property that you are giving, that will not be treated as, the value of it will not be treated as what, as cash payment. So that is the point about 48.2. Now let's come back to a very important issue that we'll be looking forward to. Having already had allusion made to it when we discussed section 44. Section 44 is about issue of shares. And if you remember, a point was made that shares of different classes may be what? Issued. So now let us discuss the possible classes which the company may create as far as its shares are concerned. So I invite you to section 49.1, and I quote, the registered constitution of a company may provide for different classes of shares by attaching to certain of the shares preferred, deferred, or any other special rights or restriction, whether as regard dividend, voting, repayment, or otherwise, unquote. Now, what this provision 49.1 means is that it is permissible where the company has a registered constitution, where the company has its own tailored constitution, in the constitution, for example, to provide for different types of shares, different classes of what? Of shares. And 49 has just given us an example of the different classes which the company can decide to give. And the example or the instances provided are not exhaustive. They are not exhaustive at all. So the takeaway is that 49.1 applies where the company has a registered constitution, right? The company has a registered constitution, and then the constitution has provided for different categories of shares. And different categories means that different bundle of rights attached to the different categories or classes. And that is to say that if your shares fall within, let's say, class A, the bundle of rights which you enjoy may not necessarily be the same as the bundle of rights which shareholders in class B, for example, enjoy. So that is the point about the classification. The classification just has to do with some discrimination, if you like, permitted discrimination in terms of bundle of rights and also liabilities attached to the various shares. And that is why I was giving an example like some shares may be preferred, right? Preference shares, meaning that with respect to certain things, they will actually come ahead of other shareholders who are not preferred. Or you can have what you call like the deferred shares. That is to say that they would always lag behind, or they will have to yield to other shareholders before they enjoy certain things. And so it may be the case that you're giving certain privileges or you've attached certain restriction to those classes. And the privileges, or let me use the proper word, the rights, may be with respect to dividends. So that when it comes to payment of dividends, you say that those in certain class, they are going to get their agreed dividends paid, or certain fixed dividend. It will be paid for them anytime profit is made, or certain dividends will be paid at certain times, regardless of whether dividends are paid or not. Or you could say that when everybody has paid its dividends and we have surplus dividends. Certain class of shareholders, they will participate in the distribution of the surplus, so that those who are outside that, they cannot get some of the surplus. Now, the preferential treatment, or which you accord to certain categories of shareholders, may also be in respect of voting. Maybe in respect of voting. You could say that, yes, the law provides that each share shall has at least one vote. If you remember, when we were discussing rights of members, that each share shall have at least one vote. And I'm referring you to section 33 and 34. Now, the law did not say that you cannot allow certain shareholders to have more votes than others. It's possible for you to probably attach more votes to certain classes of shares and so on, so long as it's not violative of the Companies Act or any other enactment. So if you look at the ending of 49(1), it says or otherwise. So what that means is that the types of preferences or the special rights and liabilities which the company may attach to different category of shares are not exhaustive. So let's keep that in mind. Now, if we look at the 49(2), we are told that shares are not of the same class unless they rank at the same rate for all purposes. And that is very important. So, yes, shares are shares, but we have differences, right? We have differences. So shares in a certain class are not treated the same as shares in other class. And that is why 49(2) is saying that shares are not of the same class unless they rank at the same rate for all purposes. That is to say that shares in a certain class, they have the same bundle of rights and the same bundle of liabilities. If that is so, then we have a proper class of shares, because you cannot have shares within a class having differences in terms of the rights and liabilities. Then it will be really conceptually flawed, or to be abuse of a corporate concept of class of shares to be talking about, because if you are in the same class, then the shares rank at the same rate for all purposes. For all purposes, voting, dividends, and so on and so forth. So let's keep that in mind. Now, 49 has told us about classification of shares, and it has given us the understanding that different classes of shares may confer rights which are not actually enjoyed by other shareholders in the other classes. But the rights and liabilities which a particular class enjoy are not cast in stone. They are not immutable. They are actually changeable. So section 50 provides the rules on how you may vary class rights And as I said, class rights is nothing more than the rights which are enjoyed by shareholders in a particular class. And that is why 49.2 told us that shares which rank at the same rate for all purposes are said to be shares in the same class. So let's keep that in mind. So let's look at the rules on variation of class rights. 51. Where at any time the shares of a company are divided into different classes, the rights attached to a class shall not be valid unless otherwise expressly provided for in the constitution of a company. So let's remember that it is the constitution of the company which made it possible for different classes of shares to be what? To be created, as we saw in section 49.1. Now, the law is that it is only that same constitution which can provide the rules or the manner in which changes or variation can be made to rights which are enjoyed by the various classes. If the constitution does not actually provide for changing it, then the class rights are fixed for as long as the company remain in existence. So that is the point about 51. If you are going to create classes of shares, you have a registered constitution. If you do not want to tie your hands, you must have a clause which permits variation as and when circumstances warrant it. Now, 52, where the constitution of a company expressly forbids a variation of the rights of a class or contains provision regarding that variation and expressly forbids an amendment of the provision, in respect of the variation of rights, the rights shall not be varied, and the provision for the variation shall not be amended, except with the sanction of the court under a scheme of arrangement in accordance with section 239. Now, 52 is very important because class of shares do not just happen. Class of shares happen for major reasons. You are going to register the company. Let's suppose that you're going to do certain operations, you need some huge amount of money or some other expertise or whatever. And you get some shareholder who say that, okay, we are prepared to come on board, but we want special privileges, okay? I don't want to use the example or the situation that Ghana we are encountering with respect to IMF. That is a bad example because it doesn't really fit. But the point is that maybe somebody will say that, okay, I want to be a shareholder in this company. I want to make available so much. I want to make this particular valuable property at the disposal of the company. But I do not want to be just any ordinary shareholder, right? I want to be a special shareholder with special rights. So let that be reflected in the constitution of the company. And that, for example, is reflected in the constitution of the company, the necessary resolutions and all that are made. Now, I have a legitimate expectation to ensure that the rights which have been given me by reason of what are giving the company and which is different from that shareholder will not actually be changed to my detriment. And if the Constitution, for example, said that the rights and privileges attached to a particular class cannot be varied, then 52 is section 50 subsection 2 is saying that that will be the position. Under no circumstances can the company change it. And if the company should change it on its own, then there's a problem that will be void. However, because the business environment is subject to various changes every now and again, and there may be a need for variation of class rights or amendment of provision in the Constitution, which had previously been forbidden variation of the class rights. The window is not completely closed. There is something we call a scheme of arrangements with approval of court, which is made possible by section 239. You can invoke section 239 and you get the court to give its approval. So what is happening is that the changes you want to do is not possible because the Constitution, for example, had forbidden it, or the Constitution is probably not allowing it or is silent on it. You go to court, you make the appropriate case to court under section 239, and then the court can give approval that despite the fact that the registered Constitution is forbidding amendment of provision relating to class rights or not permitting variation of class rights, for this good cause, which have been shown, the company is permitted to go ahead and vary the class rights. Now, this will be a special dispensation because it is being given by the court pursuant to scheme of arrangement made in accordance with section 239. So let us keep that in mind. But the sorry about this WhatsApp interaction. Let me find a way to take it so that it doesn't disturb me. Good. Yeah, so 53, except as provided in subsection 2, a company may, by a special resolution, amend its Constitution by inserting in the Constitution provisions regarding the variation of the rights of a class, modifying the terms of this provision. So it is permitted for the company to alter its Constitution. If you remember, when we discussed alteration of the registered Constitution of the company, especially under section 30. If you remember section 30, alteration, amendment, and revocation of the Constitution. If we also made reference to where you want to amend provision regarding variation of class rights. And I'm referring you to section 30, subsection E. Can somebody read section 30, subsection E for us? 30E. Are we together? You're sleeping. Can somebody read? Okay, let me release the meeting. You sure? Okay. Allow participant to unmute. Okay. Can somebody read section 30E for us? Yeah.
Hello, Sir Charles.
Yes, okay.
30E. If at any time the shares of the company are divided into different classes, the rights attached to a class may be amended in accordance with section 50 or 239, but not otherwise.
Good. Thank you. So you see that when it comes to variation of class rights, the provisions relating to class rights in the constitution of the company can be amended only under two situations. Either you comply with section 50 subsection 3 and 30E, as you have read, or scheme of arrangement, a +1 to section 239, where you have to get the approval of the court. So let us keep that in mind. But because class rights are enjoyed by shareholders within a particular class, it is mandatory for a higher degree of majority of the holders of shares in that class to be obtained before you can go ahead with variation of the class right. And that is what section 50, subsection 4 is speaking to, that an amendment under this section require the prior written consent of the holders of at least 3/4 of the issued shares of each class, or the sanction of a special resolution of the holders of the shares of each class, and shall be deemed to be a variation of the rights of each class. So this is very important, that, let's say if you have class C shareholders, let's say that the authorized number of shares in class C are, let's say, 5,000. And out of the 5,000, 3,000 have been issued. Now, what section 50, subsection 4 is speaking to is that if you want to amend the provision relating to variation of class rights, then you need written consent of 3/4 of the 3,000 issued shareholders before you can go ahead to validly amend the bundle of rights attached to that particular class. So let's keep that in mind. So look at it. This is a very special majority. So 3/4, that's come to this 75%, is it? So just as we have a special resolution, as we saw when we discussed members and also constitution of the company last semester. Subsection 5, despite a provision in the constitution of a company to the contrary, the rights attached to a class of shares shall not be varied except with the written consent of the holders of at least 3/4 of the issued shares of that class, or the sanction of a special resolution of the holders of the shares of that class. That is very serious. Maybe just as a footnote, and just for probably like the bond and then the debt exchange program going on and so on. Assuming, right? I mean, it's a bad analogy, but assuming Ghana were to be like a company, and the various bonds which have been issued, because the various bonds, have got different rights in terms of the interest and so on and so forth. You probably say that each of the category of bond is like an example of a class rights. Assuming, I'm not saying that is the case, assuming Ghana were to be like a company. So therefore, if you want to vary, if you want to change the rights which holders of a particular bond within that particular category enjoy, then about 3/4 of bondholders in that particular class will have to give their written consent. But thank God, Ghana is not like a company. It is a country. And for that matter, the rules of engagement are different from what pertains to company law. But nobody should ask me a question about that. I'm not a minister. Subsection 6, a resolution of a company, the implementation of which will have the effect of A, diminishing the proportion of the total votes. This is sizable at the general meeting of the company by the holders of the existing shares of a class, or B, reducing the proportion of the dividends or distributions payable at any time to the holders of the existing shares of a class, is for the purposes of this act a variation of the rights of that class. So, section 50, subsection 6 is giving a litmus test, as it were, or is giving the criteria for concluding whether variation of class rights have taken place or have not taken place. So, if the company has passed any resolution, and if you implement that resolution, and the outcome is going to be reducing, that is diminishing, reducing the fraction or percentage of the total votes which members of a particular class can cast during general meeting of a company. That is example of variation of class rights. So the two are disjunctive, they are not conjunctive. You don't need to have the resolution doing A and B before you can say that what you have witnessed is a variation of class right. Any of them will suffice. If the resolution passed by the company ultimately has the effect of reducing the total number of votes or the proportion of votes which holders of that class can actually cast during general meeting of members, then their rights have been varied. And if their rights have been varied, you need to test that against the procedure for varying class rights. Because you've seen section 50, you've seen section 239. So you want to find out that which has occurred, which you call variation of class rights, did it actually comply with the procedure provided for under section 50 or section 239 as it were, or section 30E as we have read. Then the other typical example of variation of class rights is reducing the proportion of the dividends or distribution payable at any time to the shareholder. In other words, if the percentage of dividends which the holders of the class ordinarily enjoyed, and for which reason make them a special class, if that has been reduced as a result of a certain resolution which the company passed, then we have witnessed variation of class rights. And then we need to test validity of that by asking ourselves, did they comply with the laid down procedure for doing variation of class rights as we have been discussing? Okay, any question before we move on to look at the two main types of shares? Any question?
Yes, sir.
Yes.
Hello, sir.
Yes, please.
My question is on the treasury.
Okay.
Sometimes a company may be buying its own shares
as a result of the price of the shares
Sorry,
going down?
for the treasuries, I would say that hold on to it, because we are going to discuss redeemable preference shares and all that, and we come to it as a substantive subtopic.
Okay.
So if we can hold on to that and then just concentrate on the variation of class rights and then the class rights we should be discussing.
Okay.
Thank you. Okay, so let's look at the preference and equity shares. And I want everybody, if you haven't appreciated anything, you must appreciate section 51. It's very important, please. Because shares can be put into two main categories. What you call equity shares, which is also known as ordinary shares. So sometimes you will not see ordinary shares, you see equity shares. Other times you not see equity share, you just see ordinary shares. They all mean the same thing. And preference shares, that is shares which are not ordinary shares. Shares which are not ordinary shares or which are not equity shares are preference shares. Now, let's look at section 51, subsection 1. In this act, that is the Companies Act, Act 992, preference share means a share which does not entitle the holder of the share to a right to participate beyond a specified amount of money in distribution, whether by way of dividend, on redemption, in winding up, or otherwise. And any other share shall be referred to as equity share. Now, this statutory definition is very important. Now, what section 51(1) is seeking to do is that certain permutations or certain instances of preference shares or creating preference shares have been provided. And outside that, all other shares are treated as equity shares. So if we look at it, equity share is defined by the negative approach, or use like the negative definition. What do I mean by that? An equity share is a share which is not preference share, okay? And then you ask the question, what is a preference share? Preference share is what has been defined in section 51, subsection 1, that a share which does not entitle the holder of the share to a right to participate beyond a specified amount of money in a distribution, whether it's a payment of dividends or redemption of shares. Redemption of shares simply means that when the time agreed upon within which the shareholder may return his shares to the company and get his money back, when that has, for example, become due or as a right, then within appropriate circumstances, the company may allow the shares to be redeemed so that the shareholder can get his money back, the company will take the shares, and so on and so forth. Or when there's a winding up, that is to say that the company is going through voluntary winding up, and the company is solvent and so on, you still have a lot of assets which need to be distributed, which need to be shared. As somebody earlier asked the question, if some shareholders have been guaranteed, have been assured that they will get a certain amount of those assets, which are going to be distributed during the winding up, before any other shareholder will get some, then that is another example of preference share. So we could say that a preference share could be either in relation to payment or dividend, where you are giving either a certain amount of dividend, or you are giving a certain time for you being given your dividends over and above any other shareholder. Or, as I said, it can be in relation to redemption of shares. That is you returning the shares to the company and getting your money. Or it can be who gets what percentage of assets of the company when the company is folding up, when the company is winding up. If you have that kind of thing, that is also another example of what preference share. But where no special preference, no special, if you like, rights has been attached to a particular share, which other shareholders do not enjoy, then you do not have a preference share. So from what I have said, the class rights, which we have mentioned, also relates to preference share. But the same thing, because if you are a shareholder in a particular class, certain rights have been given to that class, maybe regarding payment of dividend. And if you do not belong to that, you will not be able to enjoy it. And for that matter, you are also a preference shareholder in that respect. So let us keep that in mind. As I said, the language we are used to is ordinary share, not equity share. But the legislation uses equity share. But as I said, in practice, is coterminous, or it means the same thing essentially as ordinary shares. Good. So 51 subsection 2 is to the effect, and I quote, a share that is not preference share shall be referred to as an equity share. So if it's not a preference share, then it's what? It's an equity share. And if we have to define an equity share is a share which is not preference share. And we know what a preference share is because the law, by virtue of section 51, subsection 1, has defined what a preference share is. So let us keep that in mind. And 51.3, that the meaning of preference share under subsection 1 shall apply to whatever name a company may designate in its constitution. And it is very important. So preference share does not need to have the label preference share in the constitution before we can say that the company has preference share as part of its shares that is going to issue. What is important is the substance, right? And at this stage of your legal studies, thanks to your discussion of equity, that equity look at the substance and not the form, isn't it? So we are looking at like the substance, like the substance of the rights attached to the particular rights or a particular share. If the rights attached to particular share are actually coinciding with what we have seen under section 51.1, that maybe either somebody is giving a certain privilege, a certain preferred status when it comes to distribution of dividend, so that he or she will get a certain specified dividends all the time before other shareholders will get. If that is the case, it's a preference share. Even if you have decided to call it maybe a golden shares class, if you call those support the golden share class, according to section 51.3, the substance of the rights or the special right which the so-called golden share class enjoy will let them be treated as well as a preference share. So it's not so much about the name. It's not about the nomenclature. It's not about the label, but it's about the substance, right? So defining preference share is more functional than just certain labels which are given. So let us keep that in mind. Okay, now we know that being a preference shareholder, you have certain rights which are unique to you, right? In contradistinction to other shareholders, unique to you in the sense that you, as a shareholder in that class, are the only people who enjoy those bundle of rights, and the other shareholders outside that class, they don't enjoy that. But there are certain situations in which the right of the preference shareholder to vote in a company may be suspended. So let us discuss section 52 before you go to sleep, because you go to work the next day. So 52.1, despite section 34. Now, if you remember section 34, when we were discussing members, we talk about right of members to attend and vote at general meeting. And section 34 reminded us that every member of the company has a right to attend general meeting, speak, and vote on a resolution before the meeting. So that is a fundamental right of every member of the company. But section 52 is telling us that regardless of that fundamental right of every member to attend and vote, as enshrined in section 34, the right of holders of preference shares to attend and vote at general meeting of the company may be suspended on conditions. So, for equity shareholders, ordinary shareholders, their right to attend and vote cannot be suspended. However, preference shareholders under specified conditions may have their right to attend and vote at general meetings suspended. So we want to look at that, and that is what section 52 actually speaks to. So 52 subsection 2, despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on a poll at those meetings to at least 1 vote per share in the following circumstances, but not otherwise. So 52.2 is first stating the general position that yes, what section 34 is conferring on all shareholders also apply to preference shareholders, despite whatever is stated in the constitution of the company. However, there are limited situations, and I say limited, and because if you look at the 52.2, the ending is said about not otherwise, meaning that there are strict conditions which must be met before you can tell a preference shareholder that he cannot attend and vote at meetings. So A, on a resolution during the period that a preferential dividend or part of the preferential dividend remains in arrears and unpaid, the period starting from a date not more than 12 months or lesser period that the constitution of the company may provide after the due date of the dividend. In other words, where you have not paid the dividends which a preferential shareholder, right? A preferential shareholder with respect to dividends entitled to has not been given. Then the law is that such a preferential shareholder is entitled to attend and vote at the meeting, even if you have anything in the constitution of the company saying that the preferential shareholder cannot attend those type of meetings. Now, the reason why the preferential shareholder will be able to override whatever the company's constitution is saying that it cannot attend meeting is that the company is owing the preferential shareholder. He ought to have been paid his preferential dividend, and that is in arrears. It's not paid. And for that matter, during that period in which the company owes it, the preferential shareholder is entitled to attend and vote, regardless of whatever is stated in the constitution of the company. Then 52(2)(b) on the resolution which varies the rights attached to those shares. So anytime the company is going to pass a resolution which will vary the rights and privileges which a preference shareholder enjoys, then automatically the holder of the preference share is entitled to attend such a meeting, despite anything to the contrary which the constitution of the company might have provided, because such a resolution is an essential matter for the preference share. That which makes him a preference share, we are going to change it. Then fairness only requires that he or she should come also take part in the decision making. And C, on a resolution to remove an auditor of the company or to appoint another person in place of that auditor. Of course, that also goes without saying, because as you know, the standard auditor of the company is very important. They actually oversee the books of accounts and various reports which are prepared by the directors and officers, and they actually provide a sort of a quality assurance that the affairs of the company are being properly run, and that the company is healthy, and it can be a going concern. And if you have shares in the company, you don't really stand the risk of losing your investment. So therefore, if you are going to change the auditor, the preference shareholder is entitled to attend and vote on it, regardless of whatever bar or if you like prohibition which the company's constitution might have provided. The preference shareholder will still be able to attend and vote on it. And the fourth scenario, that is on a resolution for the winding up or during the winding up of the company. So if the company is deciding to fold up, right, what do you call the members' voluntary resolution and so on, preference shareholder automatically can attend, despite any negative provision in the constitution of the company. So these are the limited instances in which the rights of the preference shareholder to attend and vote on the resolution at the meeting can never be suspended. So these are the limited instances. But outside these four instances, the company per its constitution can indicate those instances in which the preference shareholder may lose his right to attend and vote on resolution. So let us keep that in mind. And for that matter, if we look at the session, if we look at the subsection 3, that is the 52.3, that quote, apart from the circumstances in section 34, and subject to subsection 1 and 2 of this session, preference share carry the right on the poll at a general meeting of the company to one vote only in respect of each share. Yeah, so let us keep that in mind. A special resolution of a company increasing the number of shares of a class may validly resolve that an existing class of preference shares shall carry the right to vote, shall carry the right to the votes specified in subsection 3, additional to 1 vote per share, as shall be necessary in order to preserve the existing ratio, which the votes exercisable by the holders of those preference shares at the general meeting of the company bear to the total votes exercisable at the meeting. In other words, where you have preference share and the preference is in relation to voting rights, right? That they be given, if you like, more votes, or they have more say when you are taking decisions in the company. If the need arises to, for example, increase the number of shares in the particular class in which shares, for example, I mean, where their shares carry, if you like, more votes, so that they have more say than other shareholders. Now, if you make the alteration, the point about subsection 4 is that you shall always ensure that the balance of power, right, the balance of votes between the totality of votes exercisable by that class vis-a-vis the total number of votes which may be cast during the company general meeting is actually what preserved. So you don't dilute, if you like, the special voting power of the class of shareholders with that special privilege. So let us keep that in mind. We'll be finishing with subsession so that we continue Saturday with the rest of the provision. So 52.5, for purposes of subsection 2. Now don't forget that 52 1 has already, 52.2 has already told us that when the dividend of a preference shareholder is in arrears, then regardless of whatever prohibitions that the company has got in its constitution, the preference shareholder is entitled to attend and vote at meetings. So we want to understand how that provision actually work out, so that we can say that the dividend is in arrears. And that is why 52.5 is saying that for purposes of subsection 2, a dividend is due A, on the day immediately following the expiration of the year or the other period. So if you are a preference shareholder with respect to dividends, at the end of the financial year, right? At the end of the financial year of the company, the first day after that, you are owed by the company because you are a preference shareholder with respect to dividends. And after the specified period, and which is like usually the financial year, the day afterwards, they are supposed to pay you. Or outside that, so we have where a company has a registered constitution, on the date appointed in the constitution for the payment of the dividend for a year or other period, whether or not the dividend has been earned or declared. Good. So see, for preference shareholder with respect to dividends, for them, it's about agreed first dividend to be paid at certain times. It doesn't matter whether the company has declared dividends or not. And that is why the 52(5)(b) is also telling us that, quite apart from maybe the dividend becoming due a day after the end of, let's say, the financial year, it may well be that the company in its own constitution has also prescribed certain times for payment of dividends. And where that is the case, upon arrival of that specified date, the company owes the preference shareholder dividend. And so long as it has not paid the preference shareholder the dividend, then it has the right to attend and vote on the 4 instances that we saw, including where you are removing an auditor and so on. Any question before we draw the curtain down on today's discussion? Okay, thank you. So just for, yes.
Hello, sir.
Yes.
So